Good afternoon. Thank you very much for joining this webinar on the role of Money Laundering Reporting Officer and Money Laundering Compliance Officer. So I'm Colette Best, I'm Director of Anti-Money Laundering here at the SRA. But today, two of my colleagues will be doing all the work. So let me firstly introduce them. So I'm joined by Ross Gilson. So Ross qualified as a lawyer in Guernsey before moving to the UK for a career in legal compliance. He's held various roles at the SRA and beyond, and since 2005 he's worked as a regulatory manager, both visiting and reviewing firms' AML compliance. And Ross actually headed up the thematic review of MLROs and MLCOs that we're going to be talking about today. And Susanna Eaton joined the SRA just over a year or so ago, but prior to that she was in private practice, managing the risk and compliance team of a prominent firm. And this included responsibility for anti-money laundering tasks, so she's got a really good knowledge and understanding of the type of struggles that you might face. So I'm going to hand over to Ross and Susanna shortly. Before I do so, just a couple of housekeeping odds and ends. So we'd really like today's session to be interactive, please. So we've had a few questions submitted in advance, and we're going to be picking those up at the end of the presentations. But please do submit live questions by clicking on the button in the link below this video. And you've got a couple of options. It's really nice to know people's names and give them a shout out, but you do have the option to ask questions anonymously as well. If you've got a question that you want to ask us that you don't want us to read out, just pop your email address in and we can come back to you directly on that. So once we're done today, the stream of this video will be available on catch up. So there'll be all the slides and the links to relevant web pages on the resources page for this event. So you can share that with your colleagues who might not have been able to join us today. And finally, we love feedback. So after the event, we'll be asking you for some feedback on how today went, and also some questions about what else you'd like to hear us speak to you about. So please do that you make sure that you fill that in. So now, without further ado, I'm going to hand over to Ross and Susanna to kick us off with everything that you need to know about money laundering reporting officers and money laundering compliance officers.
Thank you very much, Colette. So, to kick off, we've got two roles here, Money Laundering Compliance Officer and Money Laundering Reporting Officer. And of these, Money Laundering Compliance Officer is the newer of the two. It only came into existence with the 2017 regulations, and it embraces all aspects of a firm's anti-money laundering compliance. Essentially, if you're holding this role, you are the person with whom the buck stops. Money Laundering Reporting Officer is the older of the two roles. It came in the Proceeds of Crime Act 2002, where it's set out under the moniker of nominated officer. And essentially their only role, at least as far as the regulations are concerned, is to make suspicious activity reports. Now, of the firms we regulate, roughly 90% or thereabouts combine these roles in one person. Now, whether you choose to do that or whether you choose to give the separate roles to the separate people is entirely up to your firm and the way that it's structured. One thing that it's important to note, though, is that whichever way you do it, there is always going to be a bit of sharing of responsibilities here or there. But the MLCO will always bear ultimate responsibility for the firm's overall AML compliance, which includes making sure that reports are properly made. It's important to remember that you can delegate functions to each other and to other people within the firm, but you cannot delegate responsibility. Now, moving onwards, do you have to have these? Well, Money Laundering Compliance Officer, it's a size and nature requirement under the regulations, but in practical terms, everybody but the smallest firm is going to need one. The important thing to note about this role is that the person needs to be board level. Now, we do understand that not every firm has a board in the strictest sense, but essentially it needs to be somebody who is involved at the highest level of the firm's operation and governance. So we're talking partners, we're talking members, we're talking directors. And if there are different levels of seniority within this, such as equity partner and salaried partner, the MLCO ought to be at the highest level. It carries the most responsibility. They don't, however, need to be a solicitor. So if you're an ABS, you could make somebody else the MLCO. With regard to the MLRO, all firms within scope need one of these, even if it's a sole practitioner. As I've mentioned, they're the nominated officer for the purposes of the Proceeds of Crime Act, which means that they do bear a certain amount of potential criminal liability if things aren't done in the proper way in terms of reporting suspicious activity and making sure those reports are properly and made in a timely fashion. Again, they don't need to be a solicitor, they don't need to be board level either, but if you separate these roles out, they need to be empowered to do the role. So they need access to all of the firm's information, they need to have the full support of the MLCO, and essentially, again, given the amount of liability, criminal liability, I emphasize, that falls on the shoulders of the MLRO, they really need to be able to make the decisions themselves. And finally, once you've decided who's going to hold these roles, you need to tell us within 14 days under the regulations, and you can do that via your MySRA account. Now moving onwards, what do they need? Well, our report last year involved speaking to 50 firms and doing an in-depth visit with virtual visit because of COVID with 25 of them. And we found that there are 3 pillars which are key to the success of these AML officers: authority, independence, and resources. Authority to make decisions and to bind the firm, independence to take action which is based on the needs of the regulations and not any other considerations, and resources, of which, as I'll go on to speak about in great detail, includes time. So to move on to authority in detail, this is not just in terms of time served or seniority in terms of your length of time with the firm. This is a role which requires leadership ability. They need to be able to carry the rest of the senior management of the firm with them and to use skills such as persuasion, influencing, negotiation, as well as simply being able to direct. Essentially, the MLCO, to put it crudely, needs to be able to stop and start the work of other people in the firm. So stop acting for this client, start doing your training, start doing your risk assessments, start putting together some information for the suspicious activity report I'm going to put in. They also need, if you're separating out the roles, as I've mentioned before, to present a united front. And the MLRO and the MLCO shouldn't be seen as essentially a route of appeal from one to the other if you don't like the answer you're given. They need to be able to walk in lockstep with each other. Now, in terms of independence, both MLCO and MLRO may need to make unpopular decisions. So these could be things which, in the short term at least, seem unprofitable. So the client who has just walked in with this marvelous idea for a business deal, which nonetheless doesn't smell quite right, may need to be gently turned away. You may need to make a report on them. You need to be independent in terms of being guided by the law and regulations. So not necessarily in terms of what appears to be in the firm's interests of profit or of expediency, but looking at what your duties are and following it. One other thing we often come across as well is personal knowledge, where people say, oh, I've known this client since I was 8, therefore do I need to collect due diligence on them? You need to be able to act objectively. So not just relying on your personal knowledge or what you think you know of a client, but looking at what's in front of you and what the regulations require. It's important to remember that the regulations allow you to use your personal knowledge to identify a client, but not to verify them. And you need both of these aspects in order to properly carry out due diligence. You need to take an objective view of risk. And in particular, I'd raise here politically exposed persons and clients from overseas. We've seen some firms who have said to us, well, if somebody from overseas tried to instruct our firm, we'd turn them away because it's too risky. You absolutely don't need to do that. And you certainly don't need to turn away clients on that basis alone. But you should have a healthy understanding of risk. Not everywhere outside the United Kingdom presents a one level of money laundering risk. There are lots of different factors to take into account, and you need to be able to make decisions based on objective, sensible criteria. Things like, for example, are they on FATF's list of non-compliant countries? Are they on the list of high-risk third countries in the regulations? Are they somewhere which is a potential flashpoint, which may lead to a heightened level of corruption? And you also need to apply proper scrutiny to each matter that comes before you. Now, this can mean even when it's making things awkward or making things slow, the job needs to get done and matters and clients need to be scrutinized properly. And I'm aware that can lead to a certain amount of awkwardness, especially if it's a client that you've acted for a long time or someone you may know personally. You still need to be able to say, no, we need to do due diligence properly on you. And that may require direct client liaison between you and the person, or it might mean giving the fee earner in charge some sort of advice as to what they need to do next. Now, moving on to slowing matters down, that brings us on to resources. And as I've mentioned, the most important one by a long way is time. Over and over again, this was mentioned to us as something which MLROs and MLCOs need. Now, this could be time in terms of having a reduced fee earning target. It could mean setting aside an afternoon a week or a day a month or however long you need to be able to keep matters going over. And tied into that, there is support and delegation. It may be that due to the makeup of your firm, you simply can't get everything that the job requires done in the time that you have available. In which case, as I've said, it's perfectly possible to delegate. And as I'll go on to shortly, this can be a very sensible idea indeed in making sure that your firm has a robust and durable AML regime. You also need access to any and all information in the firm which could be relevant. So this might be management information about things like turnover or profit from various different areas. Due diligence records, that should go without saying, hopefully, although I've been to a couple of firms where it was quite difficult for the MLCO to get hold of those records, which is somewhat concerning. And potentially staffing records. Those could be relevant, particularly when we're looking at things like screening. Now, one of the major problems that we encountered when we were doing our review of firms was overloading. It's very common for MLCOs and MLROs to hold more than one role. This is something that just happens at a lot of firms with senior figures. They might be MLCO, MLRO, Culp Coffer, staff partner, managing director, complaints partner, or any combination thereof, and potentially hold a fee earning workload as well. Now, some of these do gel together quite well. So one thing that's been mentioned to us is MLCO and Culp, for example, both compliance roles, both bearing a lot of responsibility, both covering some of the main ground. Fee earning, for example, it's been expressed to us that that is very helpful in having an understanding of what's going on at the coalface, so to speak, and having an understanding of how the firm works in reality. But put too many of these roles onto one person and it can become impossible to do any of them properly. There was a firm I was speaking to where there was one, it was quite a large firm, but there was one person who was MLCO, MLRO, Culp Coffer, staff partner, managing director, complaints partner, and a fee earner. I asked him why he had all of these, and essentially he said, I'm a control freak. Now, his honesty is commendable, but not necessarily the most efficient way to run a firm. Delegation, I think, is the key here. And if you've got more than one person in the partnership or on the board of directors, make sure that you share tasks out fairly. Maybe rotate them every couple of years. These are real responsibilities, and as I've mentioned before, but don't feel I can labour the point enough, potential criminal consequences. So make sure that you have the time to give these roles the time they deserve. How much is too many? Well, that's for you to answer, really. You can look at things like potentially adjusting fee earning targets. One firm we went to had a concept of both billable time and accountable time. And accountable time was work which benefits the firm, but not in a direct way, pecuniary way. So this person's time working as MLCO was taken into account as part of his target. Potentially, as I've said, look at sharing out roles. There are many different strategies you can use, one of which is appointing a deputy. Now, this is not a strict requirement of the regulations, but we do very strongly recommend it. There's nothing in the regulations that even mentions these, but it's one of the best ways to deal with the problems of resourcing and overloading. For a start, division of labour. As I've mentioned, it means that you can give certain tasks to the deputy to do. They may be the less sort of directly AML involved ones like training or screening, which are part of the MLCO's responsibility, but which won't necessarily need to be looked at every day. It can be very helpful for succession planning. If the MLCO or MLRO or both moves on and retires, it's much easier for someone to take on the role who has already been working in it for some time, who understands the firm, who doesn't need the same level of training and introduction as a new hire might need, or indeed somebody who'd had no experience of the role before. Absence cover. Now, I will be completely frank with each and every one of you. You need a holiday. I need a holiday. We all need some downtime to make sure that we are able to do our jobs properly. But the amount of MLCOs and MLROs we spoke to who told us that they didn't have a deputy, and if anyone needed to get hold of them while they were on holiday, they could just call their mobile, was quite concerning. For one thing, you need that downtime, frankly. For another thing, how can you guarantee that you'll be there when you're needed? You might be sailing off the Whitsunday Islands or snorkeling in the Caribbean or even just 15 miles down the road but listening to one of Uncle Gerald's interminable stories. You may not be able to react in the time frame that's needed to deal with an AML emergency. So having somebody there who can deal with it on your behalf and can make sure things happen as they're supposed to can be a massive weight off your mind, as well as making sure that the firm gets the proper cover. Which brings us on to what one of the MLCOs I spoke to in a rather macabre turn of phrase called the under a bus principle. If, heaven forfend, you were to be on your way to work and fall under a bus and ended up in traction for 6 months, how would you cope? How would the firm cope? Would anyone know where all of the information is kept? Would anyone be able to finish off that SAR that you were halfway through developing? Would anybody be able to just pick up what you'd left off? I think that goes for a lot of matters in business generally, but in particular for AML. Now, to give us some more practical viewpoints, I'm going to pass you on to Susanna, who's going to walk you through a typical first year in the working life of an MLCO or MLRO.
Lovely. Thank you for that, Ross. Yes, as Colette has said, I did do these roles in practice, so can certainly sort of empathise with potentially the struggles that you may face. So I'm now going to sort of go through what we would expect to see over a sort of year period. And whilst we have separated them out as sort of MLCO and MLRO, as the majority of you do the sort of same role, I will be sort of discussing them as a whole. So first and foremost, is your firm actually in scope of the regulations? Certainly we have some good guidance on our website, and do feel free to give us a call we can check what sort of activities have been assigned to your firm, make sure that's sort of up to date. One of the other key things is to sort of establish who your key colleagues are, and not just your key colleagues, but also, you know, the key departments. Which teams sort of pose more of a sort of AML risk, you know, within your firm. You know, understand their procedures, understand what they do, and sort of get to know the team. So moving on to SARs, suspicious activity reports. How and where are these stored? Now, you know, they are sensitive, they are completely confidential, so do make sure they are protected, be it a password protected sort of folder, or, you know, if they're in a cabinet, make sure that cabinet's locked. Only the people who need to have access to the SARs should have access to them, so really do keep them protected. Also, have you registered for SARs online? If not, you know, do go on to the NCA website, get yourself a username, get yourself a password. And, you know, it doesn't just need to be the one of you who has that, you know, both of you can do that. And also, you know, your deputy can do that. So, you know, if you do need to do a SAR, you can just sort of hit the ground running with that. And lastly, sort of on day one, you know, have the SRA been told? We still visit firms now, and, you know, we're told that so and so is the MLRO, but actually our systems say something completely different. So please do keep us up to date on your firm's MySRA. And as Ross said, there is a sort of 14-day limit to let us know. So if we move into the sort of week one, check that you've got your policies, controls, and procedures in place, and, you know, they are there and accessible. And, you know, firm-wide risk assessments are certainly quite a hot topic at the SRA at the moment. You know, so check, you know, is it compliant? Does it need updating? You know, review it, check that, you know, it does all sort of make sense and it is reflective of the sort of current situation you are in. And actually, your PCPs really must flow from your risk assessment. We've got some really good guidance on our website. We've also got a template on our website, so use that. You know, please, we really want you to use that. Make it specific to your firm, but, you know, the information's there, so please use it. As an MLRO, you really need to sort of consider how people report to you. You know, do you have an open door policy? Would you like people to contact you via email? Do you have an internal form? You know, it has to work for you, but also has to work for the firm and also for individuals. So really think about that and have that procedure in your PCPs as well. The last thing ultimately you want is someone saying, well, actually, we didn't know how to let our MLCO, MLRO know about this problem. And also going back to SARs, do you actually know how to make one? I personally find writing a SAR to be quite a sort of complex task. You know, it has to be really, you know, the amount of information you have to put down there, considering privileged information. It's not necessarily an easy task, and certainly the NCA will come back asking for more information. So familiarise with yourself with that process. Look at previous SARs that have been made. Look at potentially, you know, the queries that have come back from the NCA. I think it's also a good idea to keep a register of internal queries and sort of your, you know, your SARs. You know, it's really handy to sort of review that, you know, so you can sort of keep an eye on that and see where you're at with everything. And actually reiterating what Ross said about deputies, you know, again, it will really help you if you have a deputy who can sort of, you know, take a lot of the sort of day-to-day work off you, you know, maybe deal with the sort of queries. And by having some good PCPs and a risk assessment in place, that would really assist them as well. So if we move into sort of month one, I think this is a really good time to sort of have a deep dive into your policies. First and foremost, are they compliant? Again, look at LSAG, look at our website, get the guidance. But also make sure they are reflective, you know, as to what sort of goes on the ground. And also, how do you communicate your policies? Do you have an intranet site? Do you email them out? Are they sort of, just a hard copy? But make sure they are accurate. Make sure they're not full of sort of technical jargon that maybe people actually wouldn't understand. So really, really ensure the communication's there with them and they are absolutely relevant. If we do visit you, we will look at them and make sure, what you do, what you say you do in your policies is actually what you are doing. Looking at SARs again, have any been made recently? Do you need to chase anything up from the NCA? Are the NCA waiting for anything from you? So just sort of, touch base with your SARs register and just make sure they are sort of where you would expect them to be. And I think one of the key things to be successful, or in order to be successful in this role, is to sort of ensure that people know who you are and also actually they know where to find you. Building good relationships, having a good sort of anti-money laundering culture within your firm is absolutely imperative. When I was in private practice, I would go and attend inductions, maybe spend sort of 10, 15 minutes with new employees explaining what I do, the type of queries I receive, and really sort of making sure people knew that actually no question was a stupid question. Very much an open door policy, and making the time for someone to just come and have a discussion with you. It might just be, well, actually just doesn't smell quite right, but giving that person your time, being approachable, people being comfortable coming to you is really, really key to building good AML compliance. And I also think this is a good time to really think about, how many hats am I wearing, and actually, is it too many? Do you have time to deal with all those queries? Do you have time to absolutely fulfill your obligations when it comes to this role? Ultimately, it will be your head on the block if something goes drastically wrong. So it's absolutely imperative you put your hand up here and say, no, I cannot do this role. So if we move on to sort of year one, hopefully you have all now survived a year. We have got in here assess and address training needs. And, you may think, well, this is something we only have to do on an annual basis. We certainly expect that, but also we would like you to do training ad hoc, changes in legislation. We expect you to do training. Changes in policy or procedure, again, we would expect you to do training. And we've seen some firms sort of say, well, all of our conveyancing team have had training. Well, we want to see more. We want to see maybe accounts staff having training. We want to see even receptionists having training in anti-money laundering. Certainly the training you may give your conveyancing staff will be different to receptionists, but it's really key that, across the board, everyone is aware of, anti-money laundering and the risks your firm may face. So some of you under the regulation will be required to have a formal audit. Now, I'm not necessarily saying you need to sort of employ a third-party firm to do that training. There's absolutely no reason why you cannot sort of, perhaps somebody within your firm has some AML knowledge and they could conduct that audit for you. As the MLCO, you absolutely cannot do that, but it is your responsibility to sort of ensure that, an audit is completed. And even if actually you don't need an audit due to your size and nature, I think it's a really good opportunity to have a good review, assess the trends, look at, your strengths and vulnerabilities, update your firm-wide risk assessment, update your PCPs, review your SARs and ISARs, review your sort of register of queries. And pull that all into a review and see if you can make any improvements, see where sort of something's lacking, because ultimately, the need to monitor compliance, does sit with you, and that is under the regulations. So I'm now going to pass you back to Ross. Hopefully that was helpful. I do appreciate that was certainly a sort of quick run through, but please do ask any questions. Back to you, Ross.
Thank you, Susanna. So it just falls for me to explain some of what you might call the aftercare that is available onwards and upwards and what follows from here. So, first of all, there are a number of sources of information available to you. First of all, your first port of call really should be the Legal Sector Affinity Group guidance. Now, this has been around for some time now. The first edition came out in 2017. It was updated quite recently. It can be a little daunting. It is 200 odd A4 pages of densely written AML advice, but treat it like a textbook. Dip in, find the bit you need. You'll find an awful lot of information there about practical ways that you can deal with the kind of queries that you'll face. I'd also suggest that, particularly for MLROs, that you look at our workplace culture thematic review. That can help to understand how you can create an atmosphere in the firm where people feel able to come and talk to you. It isn't always as simple as just leaving your office door ajar and assuming that people will come to you with any issues they have. You have to not only tell people that you're there for them if they have an issue or want to discuss something or think they've found suspicious activity. They need to know who you are, how to get hold of you, and feel that they will be listened to. Now, as I've mentioned, ultimately AML decisions in the firm are for you to make, but we can help you decide how those decisions should be made. Now, the SRA Professional Ethics Helpline, of course, is there for any issues about our code of conduct and also what sort of obligations you may have under the regulations. I'd also suggest that you look at the Law Society's Practice Advice Service. Now, that is available to all Law Society members. It's run by fellow lawyers, and it's essentially there as a practical helpline for things which might not necessarily be the sort of black letter advice that you would get from professional ethics. Again, I think this is a sensible place to plug our thematic review, 3 Pillars of AML Success. If you Google it, that should come up. That essentially covers the same topics as we've been talking about today, but in rather greater detail. And finally, talk to each other. You're the experts on how this is happening in the real world. Regional forums exist where MLROs can get together, discuss the issues that they have. MLCOs can talk about how they've dealt with particular situations. I know Susanna was an enthusiastic member of at least 2. And I think if one isn't available in your area, consider starting one. I understand that there's an awful lot of commercial sensitivity around law firms and their inner workings, but really this isn't a place where you should be in competition. This is somewhere where everybody can work together for their benefit. So on that note, I'll hand back to Colette, who I think has marshalled some questions for us.
Super. Thanks ever so much, Ross and Susanna. So we've got around 10 minutes or so to answer some questions. If anything that Ross or Susanna spoke about isn't clear or you think opens up avenues of questions, please do put your questions in the link below the screen. We'll try and make sure that we get round to those. So why don't we kick off with some questions that we've had submitted ahead of time. So why don't I put this first one from Ian to Susanna. The question is, I've got a limited training budget and cannot afford an expensive e-learning package. Is there another way to make sure we comply with our training requirements? What's your thoughts on that, Susanna?
Yes, thank you. Well, I think maybe sign up to one of these lunchtime sessions would be a good start. But, I think I would reach out to people like the Land Registry. I know when I was in practice, we had an excellent speaker talking about conveyancing fraud. I also reached out to our insurers, our bankers. There are so many people who will come and send people out to talk to you. And actually, you know, all this training was actually free. And certainly your insurers want to help you out. You know, your bankers sort of do too. So reach out to people like that. You know, even your accountants. You know, all these people. You know, will provide you, hopefully, touch wood, free training. You know, and actually, I recall one time sort of just out having a coffee and getting, you know, getting into conversation with somebody from Gloucestershire Constabulary, who actually then ended up sending someone to do a talk on sort of cyber fraud and that type of thing. So really reach out to your contacts, and you know, I bet you can get some really good free training out there. So have a look at that. Try that way.
Thanks, Susanna. If you don't ask, you don't get. So why don't we move on to some of the questions that we've had submitted. So question from Graham. This is maybe one for Ross. So I've got funding to engage an external consultant to carry out an AML audit, but I'm interested in trying to carry it out internally. What are the pros and cons of those two approaches, Ross?
Thank you. Well, ultimately, obviously, it's an issue for the firm as to which method is better. An external consultant could certainly give you perhaps a more fully objective view of how your firm is operating in this sphere. It's important to remember the three ingredients of an audit, which are the policies, controls, and procedures need to be checked for their adequacy, their efficiency, and recommendations need to be made off the back of that and followed up. So adequacy, is it up to date and does it suit the firm? For example, is it referring to a compliance department that we don't have? It's something I've seen. Secondly, effectiveness. Now that's going to involve a file review of some kind to make sure people are following the policies that you've put down, and that if they are following them, as is to be hoped, that it's working in the way that's anticipated. And then recommendations to make sure that these are clear and that they're followed up in some form or other. An external one, certainly people will have the expertise to deal with giving these recommendations, making sure that your firm gets, hopefully, up-to-date advice. On the other hand, they can be quite costly. Conversely, if you run your audit internally, there may not be a direct financial cost, but of course, I suppose if you're going to get someone with a fee earning caseload to do it, it's a profession where time equals money. So anything that costs time is going to cost money. It may yet still work out cheaper to do it that way, though. You'll have to look at it internally as to whether you think that's sensible. They do, of course, though, already have a working knowledge of the firm and its systems, so they don't need to be told how the case management systems works or be told where to find the relevant files. They'll have an understanding of how the different departments work together, and people will know them. Particularly if it's a senior figure. I've seen some firms where they've got the CEO or the managing director to do this. They know the firm better than anybody and can give really good, structured, tailored advice. It's also helpful with recommendations, frankly, because the person who's doing the audit needs to monitor the recommendations. Now, that's particularly perhaps difficult if you get someone in externally, because you would need to get they can make the recommendations certainly, but whether they'll be followed in or not is really up to the firm. If it's someone like the managing director or the CEO, they can badger, they can remind people, they can make sure that they're followed up properly. I saw a really good audit done by quite a large firm once, which had been done by a paralegal. And, you know, he did an excellent job, but ultimately he's not going to go round to the board and tell them that they haven't complied with with recommendation 1.3 or whatever. So I hope that's been useful. There are pros and cons to both of them, but ultimately just keep those ingredients in mind.
Brilliant. Thanks, Ross. So we're running a bit short of time, so maybe we'll do sort of a few final like quick fire questions that have come in. So an anonymous question which has come in about legal professional privilege. So is legal professional privilege ever a defence for a solicitor failing to make a disclosure when the solicitor knows or suspects or should have reasonably known and suspected that a client is engaged in money laundering as per section 330 of the Proceeds of Crime Act? So actually, I'm going to pick that one up, and the answer is really it depends on the situation. The best advice I can give you is to read thoroughly the section of the LSAG, the Legal Sector Affinity Group guidance that deals with this, because it is an incredibly detailed and thorny subject, and it's well worth taking the time to understand it fully. The bullet points I would say to consider would be, firstly, has legal professional privilege actually attached? So is the advice covered by advice privilege or litigation privilege? If so, generally those are absolute, but what you would then need to consider is, do you know that a transaction is taking place that would constitute an offence under the Proceeds of Crime Act? And if you know that that is happening, then you can consider various exemptions to legal professional privilege. So you may be able to disclose under the crime and fraud exemption. But essentially, it is exceptionally complex and situation specific. So do make sure that you do thoroughly read the guidance and take specific advice on your individual situation. So why don't we then move on to a couple of other questions that we've had through. I'll put this one to Susanna, actually. So I've recently submitted a SAR to the NCA. Can I also submit a copy to you, that's us at the SRA, to show that we've tried to mitigate the risk? So that's a no, isn't it, Susanna?
Unfortunately, that is a no. Only the people who sort of need access should see them. Only send them to the NCA. There may be occasions if we visit you, we might review your SARS sort of register, but no, please do not send them to us via email or post. That's no.
Brilliant. Yeah, we definitely don't want to be submitting, receiving copies of SARS either electronically or in hard form. Thanks. Great. Another question that's just come in, actually, this again is an anonymous one. Why don't I ask firstly Ross and then Suzanne a few views on this? So in practical terms, how can an MLRO learn how to make a SAR if they haven't done so before and the firm hasn't done any previous ones? Are there examples, resources and courses available? Can you direct me to any? Thank you.
Okay, well, I think the first thing to note here is that there is a new SARS submission system in the offing. We haven't seen the details of it, but it is apparently going to come out later this year, which may invalidate anything I have to say on the subject now. Suffice it to say that we hope that there'll be plenty of resources around the new system when that comes out, so that everybody, us included, can learn about how to use it. As things currently stand, the system that SARS Online is currently using is fairly old and has perhaps evolved in a bit of a clunky way, it's fair to say. So you're presented with a form that asks for what in the face of it are quite simple things. So who are you? Who does the matter concern? Are there any companies involved? What are the details of the people involved? And then a sort of narrative box where you can put in the details of what your suspicions are and a bit of background information. Now, on the back of this, I think it's the NCA have a lot of guidance on how they like SARs to be filled in, which isn't always apparent from the face of the document itself. So, for example, there are things called glossary codes. These are just little codes that you put in at the top of the narrative box, which helps the NCA sort where it's supposed to go. Those are very helpful. when they're asking for details, it's not explicit on the face of the form, but it's helpful if you can get things in like, for example, telephone numbers or email addresses of the people that you're dealing with. These can be very helpful because while people may use aliases, they don't always bother to change their phone numbers or email addresses, which can be a very helpful way for the NCA to track people. And just talking now about the content, it's very important to remember that you're not writing for the consumption of another lawyer. This is going to be somebody who may not understand legal technical language, so do try to make it as understandable as possible. Make sure that you've got as much detail as you can. There's plenty of guidance on the NCA website. Do have a look around, and there's also a SARs in Action newsletter that you can sign up to, which gives some helpful practical advice.
Super, thanks, Ross. Susanna, what would be your practical tip for someone coming into this role who's never submitted a SAR before? Where would be the first place you would signpost them?
Okay, actually, on the NCA website, they have got quite a good sort of 23-page PDF, and it's sort of all about the how, why, what, when, who. I would really sort of follow that. And actually, what I would probably do is print off some paper forms and just sort of practice a few. You know, there's no harm in doing that. You know, if you have the time to do it, but there is some good guidance on the NCA website, so I would have a look there first of all.
Brilliant. Thanks very much, both. And again, if you're looking at the guidance on the NCA website, if you think that there is a gap in guidance, do let us know, because we're always looking at areas where firms and individuals are thinking that there isn't sufficient guidance. And if that's something that would be helpful, we can always look at putting something out ourselves. So I'm just informed by our team that we're running a little over and a load of questions have just come through. So I'm really sorry that we won't be able to get to all of those. Again, the offer is there that if we haven't got to your question, I know that at least one person has sent their email, but if you want to resubmit it with your email address, then we can get back to you individually. But as we're running out of time, I'll wrap up with one final question, which again is anonymous. Why didn't I put this one to Ross, because you've already slightly picked up on this point before. So the question is, if the MLRO and the MLCO are separate persons, can the MLRO conduct the independent audit, particularly if she or he is not a fee earner? So what are your thoughts on that, Ross?
I never like to say a blanket no, but it seems very unlikely that they could demonstrate the kind of independence needed, simply because in the majority of firms, the MLRO is going to be involved in putting together the firm's PCPs and making sure that, policies, controls and procedures, and making sure that those are properly being followed. The other thing is, of course, that they are themselves responsible for the policies, controls and procedures in relation to submitting suspicious activity reports. So there is potential there for them to be marking their own homework. Now, ultimately, I think that's the key question that you should be asking yourself when you decide who is to become the auditor. Is this person marking their own homework? It might not just be the MLCO or MLRO. I've been to quite a few firms where the head of compliance has been involved in drafting the AML policies. Ultimately, this isn't just about conflicts of interest or anything. It's also about document fatigue. We all know that once you've drafted a lengthy document, you can find yourself reading it and rereading it, particularly if you have cause to look at it a lot, and you find yourself skimming over things. It's very helpful to get an extra pair of eyes. I would never like to say no, but I think the circumstances in which an MLRO could do this properly would be very, very limited. They would have to have no fee earning role. They would have to be pretty much divorced from the rest of the firm's AML structure. They would have to have the kind of distance from the MLCO, which would probably stop them working together effectively.
Brilliant. Thanks, Ross. All right, we're coming up for sort of 10 minutes over time, so I'm going to wrap things up there. So as I say, if you haven't had your question answered, and I know there are some that we haven't gotten to, do ping us it with your email address. We'll try and come back to you individually, or we might wrap it into a future webinar. And on that note, we really want to know what you thought of this webinar. So was it useful? Is it the type of content that is helpful to you? What sort of content would you like to see covered in the future? It'd be great if you could click on the evaluation link below this video stream and let us know what you think. It only takes 2 minutes. It helps us shape our future webinars, and it really does help us improve them. We do have a series of future webinars coming up on anti-money laundering, so please do check back on the SRA events page for further information on those. And then I think all that remains to say is a massive thank you to Ross and Susanna and the SRA behind the scene teams for putting on the webinar today, and to you guys for watching and for those brilliant questions. So thank you very much and enjoy the rest of your afternoon.